Minesh-shaytanir-rajim. Bismillahir-rahmanir-rahim. Semester 8, Law of Evidence 2. Our topic is leading question. Introduction. First of all, we should have a look of our topic, leading question. A leading question is one which suggests to the witness the answer which it is desired by the party, cross-examining the opponent witness to give a desired answer. A leading question is framed in such a manner that it throws a hint as to or suggests directly the answer which the examiner desires to elicit from the witness. Article 136 to 138 of the Quaid-e-Azam Order 1984 deals with it. The court shall permit the leading question as to the matters which are introductory or undisputed, or which have, in the opinion of the court, been already sufficiently proved to the satisfaction of the court. Definition. The definition of leading question is any question which suggests that answer which the person who puts it wishes or expects to receive is called a leading question. Now we shall have some instances of leading question. Is not your name so and so? Do you not reside in such and such place? Are you not in the service of such and such a person? Have you not lived so many years with him? These are the instances of leading questions. And when we look at these questions, we are seeing that there is a hint in these questions, the desired answer which the person putting it, and the witness will take hint that what he should give the answer of this question. What questions regarded as leading questions? The following are the questions which are regarded as leading questions. Questions assuming a controversial fact. Questions calling for answer yes or no. Alternative questions. First, questions assuming a controversial fact. A question is leading where the question assures any fact which is in controversy so that the answer may really or apparently admit that fact. Number 2, questions calling for answers yes or no. A question admitting of being answered by a simple yes or no is regarded as generally a leading question. Number 3, alternative question. A question is an alternative one or in alternative form when the question is like, did you or did you not refuse? Does not admit of an answer by a simple yes or no. Whether question in this form is leading or not depend upon whether it does or does not suggest any particular answer. When should leading questions not be asked? The following points are important to explain under section 137 of the Quaid-e-Azam Order 1984. First, examination chief or examination. Leading questions cannot be asked in examination chief or examination, but there are also some exceptions. Objection of adverse party. It is the right of adverse party should raise objection against asking any leading question. In fact, it has been provided in Quaid-e-Azam Order that leading question cannot be asked in examination in chief or examination when adverse party objects such questions. Exceptions. Now we come to the exceptions of this rule. An exception also be provided that leading question can be asked when court permission or court permit it to ask leading question during examination chief or examination. But this is subject to the objection of the opposite party, and the court will decide the matter that the permission would be granted or not to ask a leading question in examination chief or re-examination. This is the discretion of the court to permit or not to permit a leading question in examination chief or re-examination. When court can permit leading questions. Under the following circumstances, court can permit leading questions. Number one, introductory matters. A witness may be asked about matters preliminary to the main topics of controversy. For example, witness name, age, residence. Number two, undisputed matters. A leading question may be asked in examination in chief in undisputed matters. Proved matters. Court can permit to ask leading question in examination in chief or examination when court is satisfied that the matter already sufficiently proved. When leading question may be asked. Leading questions may be asked in cross-examination. Leading questions are permitted in cross-examination. Examination in chief, leading question can be asked in examination in chief if court permit to ask leading questions. Re-examination. If court permits leading question, party when calls some witness can ask leading question to such witness during re-examination. Now we will discuss what are the advantages of a leading question. The main advantages of leading questions are as follows. To converse time. Time is precious and more so in the modern world. However, once there is debate or discussion even on the most trivial subject, no amount of time might suffice to arrive at useful conclusions. Once a certain amount of time is expended, the opponent might be able to escape defeat by appealing to the busy schedule and his need to go. Thus, in spite of all the energy spent, the apologist might have to go home without coming to the real issues. At the same time, this incompleteness might give a false sense of pride to the opponent to truth, who feels that by not losing the debate he has won his case. Thus, some strategy to converse time by eliminating unnecessary discussion is essential. Leading questions play a very important part here by separating the significant from the trivial and the useless. Second, to lead into a definite direction. Leading questions involves aiming at a goal that then asking questions in a manner to lead the respondent into that definite direction. This can be achieved only if the general and aimless questioning is abandoned and leading questions asked. To get to the root of the problem, a logical analysis of statements, cause and effect, deductions, and other ways of reasoning often uncovers many hidden assumptions. Further, often the issues involved are so complex that the discussion goes on without ever touching the root of the problem. Only leading questions can expose the hidden assumptions and the root cause of the problem being discussed. Often the discussion might prolong for hours without actually discussing the root problem. Only the appropriate questions planted at the appropriate time can lead people to address the real issues. And lastly, the advantage is to convince the respondent. Often the person responding the apologist is not convinced of truth or is not willing to see the truth. Affirmation made by the apologist don't create much impact because the logical thinking and reasoning has passed only through the apologist's mind. Often the issues involved are so complex that the opponent is unable to see it unless he is forced to go step by step through his process of reasoning and deduction. At other times, the willingness of the respondent is so opposed to discovering truth, he does not come to the right deduction unless he forced to reason step by step. Only leading questions can help the apologist to force the opponent to go through the steps needed to arrive at truth. So these are the advantages of leading questions. Now we come to the conclusion of this topic. To conclude, it can be stated that examination in chief, cross-examination and re-examination all make one statement. Basic purpose of such statements to extort truth so as to dispense complete justice. However, leading questions in examination chief or re-examination can defeat this purpose. Due to this reason, it has been provided that leading questions should not be asked in examination chief or examination. So the important point of our topic is that a leading question is that question which suggests the answer which the person putting it expects to receive. Leading questions are allowed in cross-examination. Leading questions are not allowed in examination in chief or examination, but can be asked with the permission of the court. Thanks.